Good morning, everyone. This is Victor Sahn of SulmeyerKupetz. I am here with Sandy Mallory of Shumaker Mallory, and we're here to talk to you about commercial and office leases, both prior to and then after the filing of a bankruptcy case or a Chapter 11 case with respect to the commercial or office lease. Before we start, Sandy, why don't you, if you don't, introduce yourself?
Hi, I'm Sandy Mallory from the law firm of Shumaker Mallory, LLP in Los Angeles, and I am a real estate attorney specializing in leasing law, commercial buildings primarily.
Okay, why don't we jump into the materials, which you should have in front of you. And the perspective we wanted to bring today is not one that just simply focuses upon the bankruptcy issues attendant to a commercial or office lease. I wanted to talk also about the pre-petition issues right back to the point in time that the lease is actually negotiated, drafted, and of course signed. And Sandy has, while she certainly has a familiarity with bankruptcy issues, she is expert, to say the least, when it comes to leasing issues. And while a great deal of her practice is focused on representing tenants, she certainly understands the landlord's perspective as well. So, Sandy, why don't we start with having you talk about some of the drafting issues that come up and how things that can be the subject of a negotiation between a landlord and a tenant ultimately have consequence if the tenant winds up eventually in a bankruptcy case.
Sure. Thank you, Victor. Well, as we all probably know, an unexpired lease can be assumed or rejected in bankruptcy. So a landlord, when there is a default under the lease, wants to be sure that it properly terminates the lease, and preferably before the tenant files for bankruptcy. As a tenant, you want to file your bankruptcy as soon as possible, preferably before any notice of default is served on you, or certainly before any cure period expires, which is in your notice that you receive from the landlord. As a starting point, from a landlord's perspective, you really want to be sure that there is a clearly defined default if you're going to file or serve a notice on the tenant that there's been a default. Let me give you a couple of examples where some problems can occur. Typically, leases will have a separate default provision where they define a default as the non-payment of rent within a certain number of days, or the non-performance of a covenant under the lease within a certain number of days after notice from the landlord. And then leases also have other provisions that will say, for instance, that if you don't provide an estoppel certificate or a subordination agreement or a financial statement or some other document, say within 10 days after request from the landlord, that constitutes a default. So there's a bit of a conflict there if you've got 10 days for not providing some sort of notice, but yet the default provision says you have 30 days to cure a covenant. So you want to make sure that the lease hangs together with all those different provisions. And the best way to avoid a problem here is to either put a separate event of default as being, not providing a document that the landlord requests within 10 days, or just adding a carve-out to the 30-day covenant default provision that says except where a shorter period is specified elsewhere in the lease. And that will help you there. Also, problems arise when you define what gives rise to the landlord's right to terminate the lease. Often the default provision will define what is a quote-unquote event of default as being items that I just talked about, and then it will say that the landlord can terminate in the event of a default, quote-unquote event of default. So you want to be sure that anytime you say there is a default under the lease, you use the same term, event of default. Otherwise, the tenant's going to have the door open to come in and argue that, in fact, a quote-unquote event of default has not occurred, and therefore there is no right on the part of landlord to terminate the lease. A particular issue arises when you're working with the AIR lease, which is the a lease that a lot of attorneys use. By the American Real Estate Association issues that. And if you use that lease, there is strange terminology used, so you need to be aware of this. They define a default as a violation of the lease, but it's a breach with a capital B if you fail to cure that violation within a certain number of days. So if you're going to be adding any language to the AIR lease, make sure that you use the term breach instead of default, because you want to be able to include anything that you've already received notice and failed to cure. Otherwise, you're going to run into problems. One of the easy things to cut short the time during which a tenant can file a bankruptcy is to say that any notice that is given under your default provision is in lieu of and not in addition to the notice required under California Code of Civil Procedure, Section 1161. You want to do that because if your lease doesn't say that, then you're going to have to give an additional 3-day notice after your tenant doesn't meet the cure requirements that are under the default provision. So always include, this is in lieu of any notice that's required under CCP 1161. When you include that language, however, the notice that you serve on the tenant that it has violated the lease will have to include everything required for a proper notice of default under 1161.1, which is going to give you all the requirements for serving a proper notice to pay rent or cure, or a notice to pay rent or cure, or to perform or quit. So basically, the first thing I want to talk about in that notice that you serve on the tenant after it fails to cure a default, you want to be sure to not only name the correct parties, which would be the tenants under the lease, but also to name any other parties who might have a claim to a right of possession of the premises. And the reason you want to do that is because anyone can come up later on and claim that they were possessing the premises and did not receive the notice, in which case your notice will fail and you'll have to start all over again. This actually happened to us in a case, and we had a lease that specifically said, it was a residential lease, it specifically said that X, Y, and Z were the tenants under the lease, and we served a notice evicting X, Y, and Z, or a notice to pay rent or quit on X, Y, and Z, and then as we're about to get the sheriff to lock out the tenants, a person appeared at the sheriff's office and said, gee, I never got this notice. And we had to start over again. So I learned that the hard way, and hopefully you won't have to. The thing you need to be aware of when you serve a notice on the tenant, a notice of default that complies with the requirements of Section 1161, is that the rent has to be exact or nearly exact in the residential context. That is not the case in commercial leases. And typically, if you're within 20% of what the actual rent is, you're going to be okay with a commercial lease. And the reason they're not so strict on commercial leases is because of all those pass-throughs of things like taxes, insurance, and operating expenses, which really aren't determined until the end of the year. And during the year, they're based on estimates. So anything you put in a 3-day notice is going to be an estimate. What I would suggest, however, is in your notice to the tenant, your notice of default, make sure that you say the amount of rent that you're quoting is based on the landlord's good faith estimate. Next, the rent that you put in your notice to the tenant cannot go back more than 1 year. The statute specifically says that you have to file a notice within 1 year of the breach. And so you can only go back a year. That doesn't mean you can't collect further back from that, but you'll just have to file a separate lawsuit. You cannot recover rent beyond 1 year back in an unlawful detainer action. I'd like to talk a little bit about late fees. Most landlords have in their lease the right to collect both interest and late fees. Late fees are considered liquidated damages. They are not considered quote-unquote rent. So you cannot as a rule, request late fees to be paid or put them in your 3-day notice as part of the rent that's due. If you do, it'll be kicked back and you're going to have to start over again. So normally when you put late fees in your lease, you're going to want to have the magic language that says that the landlord will incur costs not contemplated by the lease if there's a late payment, and the exact amount would be difficult to ascertain. If you don't have that language, you may not be able to enforce a late fee provision. One creative alternative to approaching this late fee conundrum is to file 2 separate 3-day notices against the tenant, one for the non-payment of rent and one for non-payment of the late fee. I'm not sure that's going to work very well, because I think if you're going to call a late fee rent and serve a notice for non-payment of it, and you also have a provision for interest, what might happen is the court may look at the late fee as being part of the interest, and it will call it usurious, and you'll have a failure there. So I would say the safe way to handle this is to just file your notice as having just as the amount of base rent, just for the amount of base rent that's due, and then file a separate action to recover late fees. Partial payments of rent. A landlord's acceptance of partial payment of rent after it files an unlawful detainer action can defeat an unlawful detainer action unless the landlord gives notice to the tenant in advance that the acceptance of a partial payment will not constitute any waiver of the landlord's right to recover possession of the lease. Most leases have this language, but make sure it's in there. If it's not in there, you can also put it in the 3-day notice. And of course, that is served prior to the filing of the UD action, so that is going to protect you there. But I think you want to make sure that there is such language somewhere, whether it's in the lease or the 3-day notice. And if you forget to do it in the 3-day notice, just make sure you do it prior to filing your unlawful detainer action. Forfeiture provisions. Forfeiture provisions states that a forfeiture provision will state that if the tenant fails to cure within the time set forth in your notice, then the landlord hereby declares the lease forfeited. This is a critical thing to include in your 3-day notice or your 10-day notice, whatever it may be. And the reason for that is because it's this clause that triggers the termination of the lease, not the unlawful detainer action. Your unlawful detainer action is filed because the tenant won't leave after you terminate the lease, but it's actually that notice that terminates the lease. So you want to make sure to include that forfeiture language in your notice to the tenant. Let's see, if you don't have that forfeiture provision, by the way, the tenant can still cure the breach after the cure period expires, and they can retain possession of the premises. Now I'd like to talk a little bit about service of your notice. We'll be quick about this. The service has to be by personal service, handing it directly to the person, or using substitute service, which means you have to leave a copy with a person, quote unquote, of suitable age and discretion at the tenant's residence or business. And typically someone who's about 16 years old or older will qualify to be a person of suitable age and discretion. Simultaneously mail a copy of the notice to the tenant if you're not serving it directly on the tenant. The third way you can do it is called nail and mail, but you can only do nail and mail if you try to do substituted service, and you can't. The nail and mail is just nailing a copy of the notice on the front door of the premises, and then at the same time mailing a copy to the tenant.
Sandy, if I could just interject, what are some of the notice issues that you've come across that have been problematic? You mentioned one earlier about not giving notice to unknown people, where you actually came across a problem with the process you would employ client. But what I mean, the notice issues, from my view as a it's non-bankruptcy lawyers as it relates to leases, is really a trap for the unwary.
Oh, absolutely, and especially if you're serving that notice as your initial default notice and you're making it the same as the 1161 notice. because you need to have all of those things. And you know, the form of the notice doesn't matter, by the way. You can send a letter to the tenant. It just has to include all the things that are required under the statute. So, but I would say the biggest pitfalls are the amount of rent, you know, not going back further than 1 year, and if it's a residential lease, being very precise. If it's not a residential lease, to do your best to stay within 20% of what the actual rent will be. You're also going to want to put in the notice, you have to state where the keys can be returned if they decide to quit instead of, you know, curing, or where payment can be made if it's a non-payment issue. You have to specifically say, you can pay at this location to this person between these hours, and you have to be very specific about that.
I have a situation now in a case that's actually, which I'll be talking about in a little bit, going up to the Ninth Circuit as we speak. It's actually before the Ninth Circuit, and it concerns a notice issue with respect to termination of the lease, and that is literally the issue on appeal, whether or not the landlord in our case complied with the notice provisions of the lease with regard to the pre-bankruptcy notice which it gave to the debtor tenant. And it's important because it concerns an under-market lease, a very valuable asset in the bankruptcy case, and a lease that has a purchase option attached to it, which is itself separately very valuable from the lease that the debtor has. I wanted to highlight that, and you know,
was it the method of service that was a problem, or was it what was actually in the notice itself?
It was the timing, and whether or not there was compliance with the timing requirements for giving notice of a default and lease termination as provided for in the lease.
Yeah, that shows that you have to be very, very clear in the lease about what constitutes a default and how much time someone has to cure. And like one of the first things I pointed out was, you know, if you fail to give the landlord an estoppel certificate within 10 days, but your default provision says you have 30 days to cure a covenant, then the tenant's going to have room to argue. You know, if you're going to serve a default notice after 10 days, the tenant's going to come in and argue, no, I have 30 days, because under the default provision it says that, you know, these are the things that give rise to the right to terminate. So you need everything to work together very well, and you need to watch out for anything outside of your default provision that says this is a default, and make sure it ties into that default provision. That's a big problem I see in lots and lots of leases that people don't watch. Another one being that they use different terms to describe defaults. You know, one would be default with a capital D in their default section, but then they casually use a small d elsewhere. Again, a tenant can say, well, small d doesn't mean big D default, and the default provision has specific items that are big D default, and I didn't do that. So you have to be very careful how you draft and that your terms are very consistent.
Thank you.
One of the issues that arises is, what if a bankruptcy is filed after the 3-day notice or 10-day notice or what have you? Again, I'm using the term 3-day notice loosely, because if you have a provision in your lease that says your notice can be served in lieu of the notice required under 1161, it may be a 10-day notice, it may be a 30-day notice. It just has to be at least a 3-day notice. So what if the bankruptcy is filed after a 3-day notice but before the cure period expires? I think in that case there's a real risk that the bankruptcy court will consider the contract executory under Section 365 of the Bankruptcy Code, and that they'll permit the trustee to assume the contract. So that's definitely a pitfall. Obviously, the shorter the period to cure, the less time the tenant has to file the bankruptcy. So again, you know, timing is critical here. You want to get the termination as soon as possible if you're the landlord, and if you're the tenant, you want to get the bankruptcy filed preferably before the cure period runs out on any notice that you received. I also wanted to just talk about a couple of other things that might be deemed unforeseeable provisions. Rights of redemption. There are some statutes, specifically Civil Code Sections 3275 and Code of Civil Procedure 1174 and 1179, that permit a tenant under some circumstances to redeem or reinstate a lease after it's been forfeited. And more and more leases I see these days actually have the tenant waiving any rights of redemption. In fact, it's been pretty rare that I've seen a lease recently that has not had a waiver of those rights. The question is whether those rights are enforceable in bankruptcy, and I think the answer is unfortunately maybe, because I've heard of cases that have gone both ways. And so I think it's going to depend really on the facts of the case, and specifically whether the debtor in possession or the trustee has the funds to cure the default and make the landlord whole. That is to pay all of the damages, all of its attorney's fees, and to be able to demonstrate that it can pay the lease going forward. Also wanted to touch briefly on use provisions. Overly strict use provisions in a lease are sometimes disregarded by the bankruptcy court if they consider it a de facto anti-assignment clause. In the shopping center context, the bankruptcy code has actually some protections for landlords that own shopping centers, which is really good because landlords have a real interest in protecting exclusives that they grant to other tenants, in protecting the tenant mix at the center so that you don't have too many conflicting uses, to protect its flow of rent, including percentage rent. So the bankruptcy code does afford some protections in those arenas, and I think Victor's probably going to be touching on those a little bit later. But the reason I bring it up now is because in some cases, whether a group of retail establishments constitute a shopping center for purposes of the bankruptcy code may not be so clear-cut. So as a drafting tip, I would say you would really enhance your position as a landlord if you include a provision in the lease that says that this lease is a lease of real property in a shopping center, quote unquote, and that the provisions of 365b3 of the bankruptcy code apply to any assignment or assumption of the lease. Many leases these days also contain a provision in the assignment and subleasing clause that says if the lease is assigned or subleased by the tenant, and the amount that they receive from the sublessee or assignee is more than what they're paying under the lease, then they split the profits with the landlord. This actually should be after the deduction of all the tenant's costs after it assigns or subleases. But the reason I bring this up right now is because a bankruptcy trustee may look at this as something which impedes its right to realize the benefits of the lease and may disregard this sort of clause. And in fact, they may just say that all the profits belong to the trustee estate. I've seen in the leasing arena a lot of arguments around this point. A landlord will often say, gee, this is my property. If there's any money to be made off of it, it should be all mine. And the tenant on the other side says, gee, landlord, you negotiated a lease to get X amount of rent. You're getting that because I'm still primarily obligated under the lease, so I should get all the upside. And by the way, you're not sharing any downside if I don't get as much as I'm paying under the lease. And that's where this profit sharing provision has actually come about. I think everybody just kind of agreed, let's agree to disagree and we'll just split the kitty. And again, I think a bankruptcy trustee would probably want to argue the same argument that the tenant makes and keep all the profit from any sublease or assignee, and I think that would probably be affirmed by a court. Recapture clause. Assignment and subleasing provisions often contain a provision that says if the tenant is proposing to sublease or assign, that it has to let the landlord know, provide all the documents to the landlord, and the landlord can then just terminate the lease. Bankruptcy courts typically do not enforce these types of provisions, but might, as a landlord, might be able to get around that by, instead of saying that you have a right of recapture, that you would have a right of first refusal and that you could assign or sublease the premises back under the same terms that were offered by an unaffiliated third-party assignee or sublessee. This is potentially a way to get around this, but it's not the best resolution just because any party who might come forward to offer up, to assign or to accept an assignment of the lease or a sublease would probably feel a chilling effect. If they knew that the landlord could then come back and exercise a right of first refusal, they'd be less willing to enter into any negotiations to assign or accept an assignment or sublease of the lease. And I think that's about all I am going to be talking about, so I'm going to turn it over to Victor at this time.
Okay. Sandy, thanks very much. That was tremendous. I appreciate it. Before I start, I wanted to indicate, number one, that there is an ability for people attending to pose questions, and if we have time at the end of our presentation, we'll answer them, but the worst that will happen is that we will email you answers later today. And secondly, while you have these materials as part of the presentation on your screens, we're certainly happy to send them to you in PDF or other format so that you can have them in that form if that would be helpful. And with that, I will go into the bankruptcy issues or highlighting of the bankruptcy issues attendant to a office or commercial lease. First of all, is just a few baseline points. These issues are controlled by primarily, if not entirely, by Section 365 of the Bankruptcy Code. Section 365 of the Bankruptcy Code over the years has become unwieldy, lengthy, and drafted and amended at various times to cover more and other situations, primarily around the intellectual property arena and similar kinds of things that have come up in bankruptcy cases as technology and innovation have brought issues into play that didn't exist when 365 was drafted and implemented 35 or so years ago when the code was first enacted. But the provisions of Section 365 that relate to non-residential leases of real property, which is what we're primarily here to talk about, are found generally stated between Section 365A and F. Now, those subsections cover other issues as well, but within those subsections, you're going to find most of what you need to know as it relates to a non-residential lease of real property. The first point beyond the statutory framework is these leases are, first of all, property of the estate. And as property of the estate, as Sandy, I think, really explained clearly in her talk, what the debtor gets after it files a bankruptcy case is no better than or no more than what it had as a non-debtor on the date that the bankruptcy case was filed. So, as Sandy indicated, if there was a pre-bankruptcy termination of the lease, the filing of a bankruptcy case is not going to generate some new, different, or additional right by virtue of the tenant being in a bankruptcy case than would have otherwise occurred out of bankruptcy. There's nothing that allows a tenant to prove their position. It simply gives you the automatic stay and gives you the opportunity to assume or reject the lease or assume and assign the lease within the framework of the bankruptcy code. But if it's not property of the estate to start with, it's not going to be somehow made property of the estate by virtue of a bankruptcy filing. And in fact,
something here,
yes.
Just that most places have a provision saying it's an event of default. that a bankruptcy has been filed. What do the courts think about that?
Well, courts think about it pretty much as the statute thinks about it, which is provisions in a lease which result in the forfeiture or termination of the lease upon a bankruptcy filing are invalid and unenforceable, and that is found within the bankruptcy code. So those provisions are not going to work, and you're right, they're in every single lease I have ever seen, and they have never ever been enforceable unless they were terminated prior to the filing of the bankruptcy case. And yeah, that's really the answer to that. So you've got your lease, it's property of the estate, it wasn't terminated before the bankruptcy was filed, and now the debtor is going to try and go forward and hopefully assume the lease, or if necessary, assume and assign the lease. With regard to the assumption and rejection issues, there are very clear standards that govern that. And again, these are in Section 365 and found in subsection B1 through B3, which talk about curing defaults, paying the monetary cost or damage incurred by the non-debtor party to the lease, the landlord, by reason of the default, and providing adequate assurance of future performance. And going through those quickly, cure requirement is one where if there is a pre-petition default, a monetary default, the cure has to be a prompt cure. And prompt has been interpreted by courts, and over the years, what constitutes prompt has reduced in time, has become a more landlord-friendly concept as far as what courts are holding in dealing with the issue. And I would say experience, and this is not really with reference to a case in any sense in particular, because every case is judged by its facts and judged by the entire circumstances involved with the particular lease. Certainly a period of 6 months is going to be the outside time frame that you have to cure defaults, so that in substance you're continuing to make regular monthly rental payments which are due as the bankruptcy goes forward on a post-filing basis. At the point in time that you assume the lease, you have to make, in the scenario I've outlined just now, an additional payment so that the pre-petition defaults are cured over a period that is typically not going to be more than 6 months and might be less than that. So the cure has to be prompt. How much time do you have to do it? Under the code, you have 120 days that you are given. And that 120-day time frame can be extended, but the time frame cannot be more than 180 days. So that means that within 180 days, you have to get an order of the court providing for the assumption of the lease, or else on the 181st day, the lease will be deemed rejected as a matter of law. And this is measured by the time frame from the order for relief. The order for relief is the day of filing of the bankruptcy case, where it's a voluntary petition. Where it is an involuntary petition, it is not the date from that the involuntary petition is filed that you measure the 120 days. You measure it from voluntary bankruptcy case that the order for relief is entered. So we've talked about prompt cure. How about paying the damages incurred by the landlord by reason of the bankruptcy filing and the breach of the lease? Landlords are entitled to damages. Those damages clearly include the attorney's fees and other costs that they incur in connection with the default under the lease. Is the case, and they are entitled to that only if the lease itself has an attorney's fees provision, and the attorney's fees provision is also something that you might think about from a drafting standpoint, because we'll see two kinds of provisions. One is reasonable attorney's fees that are incurred by the landlord. A second is if there is litigation, the prevailing party is entitled to attorney's fees. If your attorney's fees provision is a prevailing party provision, then your ability to necessarily get those fees as it relates to your opposition to of the debtor to assume the lease and to generally represent your client in the bankruptcy case might be subject to scrutiny by the court depending upon how the litigation that occurs in the bankruptcy ultimately turns out. There's much question, I don't think, that you're entitled to your attorney's fees no matter what which you incurred prior to the filing of the case. But after the filing of the case, if you have prevailing party language in your attorney's fees clause, be careful in counseling your client that that's not necessarily a carte blanche that you're going to get your fees because the court could presumably and can engage in a process of saying, well, who's the prevailing party here, and ultimately decide, depending upon how the litigation in bankruptcy comes out, deem your client not to be the prevailing party if your client is the landlord, but deem the debtor to be the prevailing party and have your client as landlord face an attorney's fees claim back against it for the fees and costs incurred by the tenant's bankruptcy counsel. So what the language of that provision says is definitely very important. The last provision is that the assuming the lease or the assignee of the lease, if it's going to be an assumption on assignment, provide the landlord with what is called adequate assurance of future performance. And these words, like many words in many statutes, have been the subject of lots of litigation as to what that means. Does it have to be a traditional tenant, who is solvent, who has the ability to pay? What is the standard financially that a debtor has to meet in order to satisfy the adequate assurance of future performance standard? And generally, in my experience, courts look at where the debtor was when the case was filed from a financial standpoint and where the debtor is at the time it assumes the lease. And there's some comparison made. Are things better than they were when the filing occurred? Perhaps how do things compare with the financial statement given to the landlord by the tenant at the time the lease was entered into, if that was done? There are lots of factual inquiries that courts can make. I think they have a lot of latitude and a lot of discretion to decide what it is that that a court wants to do in deciding whether a particular prong is met. And I think I heard a judge a couple of weeks ago break it down very simply and say, I think my job is not necessarily to be granular or to be splitting hairs or cutting things with a fine-tooth comb to determine if this standard is met. I think my job, and this was the judge talking, is to assess the risk that is being imposed on the landlord by having to continue on with the tenant. And I think it's just a comparative risk analysis that this particular judge made, and I found the clarity and simplicity of that, very appealing, and I think, very accurate in that particular circumstance. So I think it was, just a good way to look at the issue. So let's talk about, just for a second, the idea of an assignment of the lease to a third party. And in this situation, and Sandy talked about it a little bit in her talk about what happens when a lease is assigned and there are provisions that may be reserved to the landlord some portion of the profit, if you will, by an assignment. Assumption and assignment is important because when the assignment is completed and approved by the court, the debtor's liability under the lease, contrary to what may occur under state law under a sublease, when the assumption and assignment is completed, the liability of the debtor as a tenant under the lease is terminated, and the entire liability falls upon the assignee, and the landlord, therefore, upon breach by the assignee, no longer has the ability to look to the debtor for the satisfaction of any damage claim. The landlord may only look to the assignee. And the standards with regard to an assignee are really similar or the same as would be the case with the debtor as someone who is assuming the lease, and that is that 365B1 is complied with, and number two, that the assignee can satisfy the standard itself of providing adequate assurance of future performance, which will mean in the bankruptcy context from an evidentiary standpoint, if your client is the proposed assignee, your client is going to have to be ready to put forward its own financial documents, financial information showing that it is able to fulfill the terms and conditions of the lease, and that it is at least as strong or stronger than debtor-tenant from the assignee is receiving the lease. And this is Section 365 F1 and particularly F2 A and B, which talk about the standard with respect to an assignee. I want to go backwards for just a moment and keep in mind the time, and that I know there's a thing or two Sandy wants to discuss when I'm done with my portion of the program. And that relates to the pre-petition termination issues, which Sandy on, and which again have been the subject of a litigation matter that I've been involved with as creditor committee counsel for almost 3 years now, and a number of appeals. And the question is, what happens with regard to a pre-petition termination and the allegation that pre-petition termination has taken place? Where does that leave you as a debtor tenant after you filed your bankruptcy case? We're talking California and the Ninth Circuit for purposes of this program, and in the Ninth Circuit, that issue has been very clearly covered by a number of cases, the most important of which is In Re Windmill Farms, which is found at 841 F. 2nd, 1467, 1471. That's 1988 case out of the Ninth Circuit. And it's really a two-part test that is applied. The first part of it is, was there a pre-petition termination of the lease under applicable state law? That's number one. Number two, does the debtor have, if the lease was properly terminated under state law, does the debtor-tenant have the right to relief from forfeiture of the lease under state law under CCP Section 1179 and Civil Code Section 3275. And the second part of that, is there a right to relief from forfeiture? Sandy indicated a few minutes ago, and it's one of the many reasons that I think this program, in terms of how we present it, works well is it gives you what can and usually does happen prior to the bankruptcy filing, and then how that all unfolds if there is a bankruptcy filing. If your client, the tenant, has waived its rights to relief from forfeiture of the lease, is that waiver going to be enforceable? And the answer in my case, which is a case called Art and Architecture Books of the 21st Century, pending in the Central District, the answer in my case, subject to any rights of appeal that may be taken, is yes, those waivers are enforceable. And remarkably, in California, there isn't any law on this. And there weren't any bankruptcy cases which talk about the enforceability of these waivers. So in a case that is, as I said a second ago before Judge Kwan held that the waiver was enforceable. That was appealed by the creditors committee who I represent and by the debtor, and on appeal, District Court Judge George Wu recently held in the last 30 to 45 days, recently upheld Judge Kwan's decision in the waiver against the debtor and against the committee. And we attempted to argue that because 1179 talks about not just the right of the tenant to relief from forfeiture, but the right of a creditor to seek, or party in interest other than the debtor tenant to seek relief from forfeiture, that because we as the creditors hadn't waived our rights, that we should be entitled on behalf of the estate to be able to assert relief from forfeiture remedy because we hadn't waived it even though the debtor had. And Judge Wu in particular was in hearing of that argument and said that our rights are no better than the debtor's rights, our rights are derivative of the debtor's rights, and because of that fact and our rights are no better, we could not separately assert the entitlement to relief from forfeiture, notwithstanding what we thought was clear language in the Code of Civil Procedure in Section 1179, which affords us that right. So whether we take that issue up on appeal, we'll have to decide in the next few days. But that is a very recent decision by a district court judge saying that those waivers are enforceable, and there's Judge Kwan's opinion also stating that the waiver is enforceable. Okay, let's go forward, having covered the pre-petition termination and concerns, and talk a little bit more in the few minutes I have left about what happens on a post-filing basis. In talking about the time frames, you have to assume or reject a lease in the 120 and maximum of 180 days that you have to do so. What happens relative to a debtor's obligation to perform its obligations under the lease between the date that the petition is filed and the date that the assumption or rejection of the lease takes place? This was a much litigated issue early on in the bankruptcy code, but amendments made probably in 1985 or perhaps shortly after that put the issue to rest of what a debtor is obligated to do. And Section 365D3 of the Bankruptcy Code makes it absolutely clear that a debtor, after the filing of a bankruptcy case and before assumption or rejection of the lease, is obligated to fulfill all of its contractual obligations under the lease until the decision on assumption or rejection is made. And we've had some argument about this point because the question is, well, what does that mean? Does it mean that they only have to make contractual rental payments under the lease? Does it mean they have to make contractual rental payments plus something else? What about all these leases and all these sharp landlords' lawyers like Sandy who say, well, every monetary obligation in the lease constitutes rent. not just contractual rent, but late charges and attorney's fees, and whatever they can throw in there under the rubric of rent, whether calling it that or separately, have to pay those. And I think 365D3 is ambiguous, and I've seen creative lawyers, high-quality creative lawyers, make an excellent argument that additional charges beyond rent by the landlord between the date of the bankruptcy filing and the date of, in this case, rejection. If they assume the lease, they have to pay all those things. But if they reject the lease, do they have to pay anything beyond contractual rent? And 365D3 is ambiguous on that point, and I've seen a high-quality and creative landlord's lawyer argue persuasively. We've yet to see if they're going to succeed, but they've argued persuasively that it includes not just contract rent, but all the additional charges that the landlord incurs as well, pending assumption or rejection of the lease, which can change the economics that a tenant faces dramatically.
Victor, can I interject something here? Typically, leases will define, the basic rent or the base rent as the amount that you pay on a monthly basis, the same amount, and maybe subject to escalations later on. And then there's another category called additional rent, which is the pass-throughs in the case of a triple net or a net lease. You can also, in a shopping center, have what's called percentage rent. That's a lot of different kinds of rent, and most leases will take the extra step to say that base rent plus additional rent plus percentage rent equals quote-unquote capital R rent, and that for purposes of the lease, that the obligations cover all the rent, and any default in the payment of any amount that is, capital R rent is a default. So yeah, I think you can take some steps in your drafting to be able to make that argument that you just told us about, that the landlord was able to make.
And on that they would succeed, because that, in my mind, is part of what constitutes rent under the lease.
Mm-hmm.
And where it works as well, or equally as well, is when you talk about CAM charges, common area maintenance charges. Might be paid on a monthly basis, might not. If they're not, and it's a matter of reconciliation and allocation at the end of the year, that is additional rent, and I have no problem with a tenant having to pay that, pending the decision to assume or reject. If it's a matter of that the CAM charges are paid monthly and there's a true-up at the end of the year, I have no problem with the tenant having to pay the true-up portion as well. But when you start adding in late charges and additional charges incurred by reason of the default, the idea that those would be paid on a lease that was ultimately rejected causes me a lot of trouble as counsel. But I warn you that 365D3 is ambiguous, and you got to be careful about how that's going to be interpreted by a court. I want to cover two more things quickly before I go back to some things Sandy needs to talk about. Number one is, what happens if there's a non-monetary default prior to the bankruptcy being filed with respect to the lease? And I'm not talking here about the bankruptcy filing. I'm talking about a lease covenant that a tenant breaches. Well, the problem with that, of course, is that as a non-monetary breach, if it's a basis for termination of the lease, that breach can never be cured. It happens, it's irrevocable, and you can't go back and change what took place. Well, the Bankruptcy Code deals with that, and 365 deals with that, and it says that those kinds of non-monetary defaults are not part of what constitutes cure for purposes of assuming a lease. So for the most part, you're not going to have to worry about those if your client is the tenant. You're not going to be able to argue as a landlord that the lease can't be assumed if your client is the landlord and thinks that non-monetary default is not curable, or the lease can never be assumed. That's just not going to work. The second thing, and I just want to touch on the shopping center leases for a moment. This is covered by 365B3A through D. And these are very, very specific provisions that have been lobbied for very hard by the landlords' lobby in Congress, by the shopping center developers in Congress, and they have done a good job, an excellent job, of protecting themselves in the areas of preserving tenant mix that Sandy talked about, and in terms of adequate assurance of future performance, where there is a specific requirement that with regard to an assignee of that lease, that the assignee's financial condition be at least as strong as the debtor-tenant's financial condition was at the time the lease was entered into. And, you know, that could be anything. That could be a company that may have been extremely healthy 5 or 10 or 15 years ago when the lease was entered into, and it would create a real issue for a potential assignee to have to meet a requirement for its financial condition that compares favorably to what the original tenant's was some years ago when the lease was entered into. But that's what the statute says. It's very clear in the statute. And so if your client is a tenant in a shopping center, you really need to read B3A through D carefully. The major shopping center landlords, I don't know if any of their counsel are on the phone, but there's 3 or 4 or 5 of these lawyers that handle a lot of this work. They are extremely knowledgeable about their clients' rights, very effective in representing them in cases around the country where leases are involved, especially debtors that have multiple leases, that have filed cases recently, like Anna's Linens, Hagen food stores, Hagen food stores, that have been some of the recent cases filed where there are many leases in shopping center properties involved. And we have the law with regard to what does it mean when it is a shopping center lease, how is that defined, and we have those in our materials. Sandy, quickly, could you go through just 2 quick issues that relate to whether or not a tenant can hypothecate their lease and the process of going out of business sales?
Sure. If a debtor in possession pledges its interest in its lease as collateral for a post-bankruptcy loan, that can definitely impede the landlord's ability to obtain possession of the lease following a default. So what you need to be aware of is that debtor in possession lenders will carve out leases from the collateral package if the leases contain specific anti-hypothecation language. So as a drafting tip, I just wanted to let you know that you want to make sure that your lease also in the assignment and subleasing section where you say, you know, the tenant shall not sublease or assign without the consent of the landlord, which shall not be unreasonably withheld, that you also say that they cannot pledge, mortgage, or hypothecate the lease, because that'll help you out as a landlord later on. The other thing I wanted to just touch on briefly was going out of business sales. Most leases prohibit any kind of auction or going out of business sales. They look bad for a shopping center to have that sort of thing happen, and landlords don't like them at all. But bankruptcy courts like to, if they're going to reject the lease, the tenant's going to want to be able to have some sort of going out of business sale. The best way for the landlord to control these and not allow them in the bankruptcy context is to define the premises as not including, and to define the common areas as including the exterior walls of the premises or the building, the roof, and just all the exterior portions, all the portions of the project that are exterior to the premises other than the storefront. And also the roof, because that will prevent the tenant from putting any signage anywhere other than on his storefront, and that can help a lot. Also, if there is any pylon or monument signage, you want to make sure that's carved out from that type of provision, so that the tenant can still have that type of signage. But that's really your best way to control that. Just make sure the premises do not include the exterior walls other than the storefront, and do not include the roof or any parts of the common area.
And I wanted to add to that before we conclude. There was a case a number of years ago called RD Furniture, of what I would call discounted furniture stores around at least Southern California, and it may have been beyond, but there was quite a few dozen of them. And they ran a going out of business sale after the case was filed in Orange County. And unbeknownst to the court and to the trustee or debtor in possession, the party they hired to run the going out of business sale didn't just sell the debtor's furniture on that basis, but actually ran through the going out of business sale furniture from other purveyors that it secured for itself, and ran under the purported banner of selling a debtor's stuff on a steeply discounted basis. This case at the time got a tremendous amount of notoriety. Everybody involved in the case looked really bad for letting it happen. And I have heard judges over the years, connection with motions to authorize these kinds of sales, make it very clear to the debtor or trustee's lawyer that we're not going to have an RD Furniture situation again, because that violated all kinds of consumer protection laws. You know, the Attorney General everybody was just up in arms about it. So be careful about who your auctioneer is, and be sure that they're following the laws as it relates to the conduct of those kinds of sales. That concludes our presentation. We went over a little bit, for which I apologize. You have our contact information, and any questions you have, you can email to Sandy or to me, and even if it's meant for the other person, we'll be sure it gets answered. And again, anybody that wants the materials in some other format, we're happy to send them along. Sandy, thank you so much. It was just terrific to do this with you and listen to what you had to say. I enjoyed it, and I hope everybody got something out of listening to us for the last hour or so. Thanks very much.